wanted to follow up from last week. Troy's about to send out a link to a podcast. I don't know if any of you all have heard about the Jerry Powell podcast. It's some geriatricians and palliative care physicians that have like a weekly podcast where they talk about different topics in dementia and palliative care. Just by luck, they had one that talked about the DICE model, which I talked about last week, or a month ago, excuse me, in our ECHO session. So if you want to learn more about it, find another good resource for learning, I highly recommend them. They're pretty good, very enjoyable. Acoustic singing too, if you're into that. So again, any cases? Other than that, I will hand off to Kelly.
All right, thank you very much. So I work at the Sanford Center for Aging, where we do comprehensive assessments of older adults. And it's frequently that questions come up about dementia, cognitive impairment, and how that impacts individuals' ability to make decisions for themselves. We have the benefit of working as a team, but we also engage family members, which I think are also important players in the team. Ultimately, our goal at Sanford Center is to respect people's autonomy and self-determination as much as possible. So this conversation about capacity, I think, really fits well. So it's important in many ways because I believe ultimately it supports individuals' human rights. We don't think of that term in this country very often, but basically we have human rights that just come naturally with us. When there's a question about capacity, we begin to think about taking away some of those basic human rights around decisions about medical care, but even such things as where they live and the medications, who administers them, how they handle their finances. So those are really basic human rights that we're dealing with. In addition, I think looking at this, the clinicians are also balancing this thing around beneficence or protection and autonomy. So we consider that also a human right. It's that the ability to exercise their free will. And as I said, the clinician frequently is balancing the protection versus autonomy. We also want to take a look at the idea of what's the right treatment at the right time. Frequently, when people talk about capacity, it seems to be an all or none thing. In other words, we're going to remove people's ability to make self-determined decisions or not. And I think as you all talked about dementia and delirium, we recognize that those cognitive conditions can change over time due to illness, disease, use of medication, et cetera. So it becomes really important to determine what's the right treatment and right decisions at the right time. I also believe it's important to include shared decision-making. In the clinic where I work, that frequently is the case. The team is asking the individual, the client we're seeing, as well as family members, what do they believe is important in terms of decisions to be made about where people live. When it comes to individuals' decisions about their pulse or their advanced directive, we certainly want to understand what an individual's values are in terms of life-sustaining treatment, removal of treatment, or not even starting treatment. And in all those situations, they're very, very complex medical decisions frequently that are being made, and it becomes important to have a lot of conversation, be sure people are all on the same page as decisions are being made. Our approach at the Sanford Center also is a person-centered approach. Again, regardless of folks' cognitive impairment or status, we want to include them in conversations along the way. As I mentioned earlier, this issue around capacity really comes about when there's decisions to be made about treatment, procedures, or complex medical interventions. And yet there are also decisions around capacity when we're talking about where people live. Are they safe living at home? Can they manage their finances, et cetera? I think with thorough conversation, good decisions can be made, people's wishes can be honored, and again, like I said, I think it behooves us to talk about this whole notion of capacity versus competence. In reading the literature, essentially, assessment of decision-making capacity is the domain of the healthcare professional. That has historically been the case, and there's no change there. What I experience frequently in practice is people talk about this notion of competence, and that's really a legal term, and that determination of competency is really something that's taken place in a court of law. physicians, psychologists, clinicians may provide evidence to a judge the person lacks capacity. Ultimately, it's the judge who determines whether or not they're competent. I just want to emphasize, when it gets to this place, that I think is a very serious consideration. When this question of competence is determined, if people lose their right to make their own decisions, that may be a permanent thing. And even though people may improve, there's no automatic reversal of that decision. Individuals usually have to go back to court and appeal that decision. And that can be really costly and time consuming. So just really recommend some sound judgment before going to the court system. And I do believe there are options in between. So capacity is defined by the Uniform Health Care Decisions Act as the ability to understand significant benefits, risks, and alternatives to proposed healthcare and to make and communicate a healthcare decision. So this is pretty standard. I think it's been helpful in terms of defining state statutes around capacity. This definition was determined by experts, psychology, psychiatry, attorneys, and clinicians as well. One of the things I want to point out is that some researchers have studied people's consent comprehension, and they found that healthy, unimpaired adults comprehend and remember less information than what we assume. So in reading this definition, there's a lot, I think, that's implied in terms of people's ability to understand things. And the best way, from my perspective, in terms of consent, is really looking at conversation. The Nevada Revised Statute also has a definition, which is very similar. An incapacitated person is unable to receive and evaluate information or make or communicate decisions to such an extent that the person lacks the ability to meet essential requirements for physical health, safety, or self-care without appropriate assistance. This particular piece of legislation really is the basis upon which a judge may determine somebody needs a guardian. They need to be a protected person. So this is the statute as of 2017. The thing that I want to really point out is that the earlier definition used the frame of incompetence. And so again, there's some language shifts that we're beginning to see legislatively as well as clinically. The former definition was incompetent means an adult person who, by reason of mental illness, mental deficiency, disease, weakness of mind, or any other cause, is unable without assistance properly to manage and take care of himself, herself, or his property, or both. It includes people who are determined to be mentally incapacitated. Again, some of that language I think is a little bit archaic, and we're really beginning to shift and recognize that there are better ways to describe folks who lack capacity to make decisions. The clinical definition of capacity is very similar. It refers, in the clinician's opinion, a person's ability to make decisions or perform certain functions. And again, recognize that the decisions may be about consent for treatment based on understanding it, or performing certain functions. And so physicians, psychiatrists, psychologists are frequently asked, can this person manage their medications? Can this person manage their finances, etc.? Again, the term capacity is different than this broad removal of human rights that we associate with competency or guardianship. And again, recognize the capacity to a specific task can fluctuate over time. And it's not necessarily a global all or none. So in other words, in a given hour, a person's capacity may change. In a given day, their capacity may change. It all depends on what's going on for them physically, what sort of disease process is going on, what medications are on board. Even some folks who have some cognitive impairment, their capacity may vary throughout the day and throughout the weeks.
Could you give us an example of a patient where they might have capacity for one decision but not have a capacity for another decision? From my perspective, I do believe people have really good understanding of what becomes important for them in terms of end-of-life care. And they have a value set that doesn't change over time. And if we have a conversation about what's important to you in terms
CPR. And again, we have to break the language down. So I think in those situations, people might have the capacity to tell us what their wishes were. Yet, when it comes to balancing the checkbook or paying the bills, they forget. They can't do the numbers anymore. And so those are some variations over time. I think typically if a person has a urinary tract infection, at the onset, they lack capacity to make decisions for themselves. And with treatment, then that may begin to change. Those are a couple of examples. I don't know if you have some others, Dr. That's great.
Thank you.
Sure. Also keep in mind that this notion of capacity really relates to the risks of the decision, the social environment and resources that support or diminish the individual's functioning. So from my perspective, I think, again, I want to separate, there might be medical decisions people make around treatment. Should I have this procedure? Should I have this surgery, et cetera? That's one host. But frequently with older adults, I think the question around capacity comes up frequently around, can they live alone? How much support do they need? How are they functioning at home? And in that regard, then the social environment makes a difference. Somebody living in their own home may function poorly in anybody's judgment, but in an assisted living facility, they might function much better because they have routine meals, they have supervised care in a way. And also, it depends on what kind of social support folks have. There are some older adults who live at home. They have frequent family contact, maybe a spouse, an adult child who comes by, or a neighbor who checks in on them to make sure they're doing quite well. So there are those individuals, though, that don't have that social support, and their self-care may continue to be neglected. They may not be taking their medications on a routine basis, and their cognitive condition deteriorates. That all the protective service team gets called in. So in thinking about the individual's ability to consent, one of the first pieces is, do they have an ability to express a choice? And I think from a consent perspective, it's conversational. How do we talk to them about what their choices are? Do we use language that's clear and understandable for them, or is it technical language? I also believe in consent processes. It's really about providing information, answering questions, and then giving people some time to maybe think about, well, what are my choices here? It may vary, again, depending on how quickly consent may need to be made. But if there's no hurry, giving people time to think about some stuff would be important, I think. So again, understanding information relevant to their treatment decision is important. How might we involve other people in that? Frequently, I think it's helpful if there's a question about somebody's decisional capacity to include the family member, because they also can be supportive. They may have the information sufficient enough to reinforce that with the older adult. People need to have the ability to appreciate the significance of the information in their own situation. And I think that becomes a little bit more complex as you describe their medical condition, what are the risks, what are the benefits. And again, keep in mind that for folks without decisional capacity problems, understanding all the nuance of risk, benefit, the procedures can be very complex. And so ultimately then people have to have the ability to reason with this information and engage in a logical process to weigh their treatment outcomes. I think it's appropriate for clinicians many times to not so much share statistics, but talk about, those treatment options. What are the benefits? And being sure people understand that. And it may be important also to put in some sort of basic language. How is this treatment going to affect your day-to-day living? What's the negative impact if you don't have the treatment in terms of your choices today, but also in the future? Any questions so far? All right.
One thing I would want to add is that sometimes as providers that, we're giving patients and family members these options, making sure that you're actually knowing what benefit you're doing, the benefit you're providing by providing that treatment option is really important too, because sometimes I feel like we offer things that don't necessarily have a great rhyme or reason, for lack of a better way to put it. And so making sure that we make rather than making other people make these decisions, making sure that we're making the best decision for the patient to begin with.
Yes, good point. Thank you. I want to go ahead and spend some time on a case. My hope is that you all engage us in some conversation. So this is a patient who's 82-year-old female. So imagine you're a psychiatrist, psychologist, a practitioner, and this case is presented to you. The individual is wheelchair-bound, oxygen-dependent. The individual is diabetic, wears glasses, and has a hearing aid. 4 months earlier, when they were hospitalized, there was a neuropsych evaluation, and they were determined to lack capacity. The family is now at a point where they believe that the older adult does have some capacity. So the referring physician in this situation, who's referred to you, did administer the MMSE. They scored 23 out of 30 points. It's not really clear what their instrumental activities of daily living capacity is. And the physician referring to you wants to know, does this person have dementia? The family's question is, does she have mental capacity? So my question to you is, how would you proceed? What are the important factors or things to consider before moving in this case? So I'll open up to the floor here.
Yeah, please feel free to take yourself off mute or write in on the chat function. We'd love to hear from you, please.
In the meantime, why don't we start a conversation here?
Yeah.
I think reviewing the medical records from the previous admission where they were declared to lack capacity might be a first step.
Yeah, and going back to your lecture, making sure they had the hearing aid on.
Yeah.
It's very important.
For me, maybe I would assess the patient how much he understands about his condition and what the consequences of taking this pathway or that pathway. So this would be stuff.
Yes.
I want to know why the family believes the patient has capacity, because they're probably the best indicator of why, like why, tell me why, how independent is this patient? I mean, you're only seeing the patient for 20 minutes, 30 minutes, so it'd be nice to know what they're like outside of your scope.
Absolutely.
Yeah, comment here that kind of shares that as well. Just have a conversation with the patient.
Correct.
Does the family have a specific reason to change a will to choose code status?
Yes. Yeah. What's the intent? One thing I want to point out is in this, the physician wants to know if the person has dementia. And my question is, what difference does that make?
Yeah.
Dementia is a broad spectrum diagnosis. And so the family's question about does she have capacity gets closer to the mark about, what is her capacity? And as the audience points out, for what purpose? I think that becomes really critically important. Why do we want to know about this individual's capacity? Other feedback questions?
And since the patient was in the hospital when the first test was done, probably he was suffering from delirium. And I mean, that could have diagnosis that was misled, that he does not have capacity.
I always like to see patients in different environments, maybe alone and then with family, because sometimes they're guided in their answers or they provide different answers with different people around them.
Good points. Yeah. So I think these things take some time. So it's important to really give the individual time because depending on sort of the outcome of your determination, it may have some impact in terms of their autonomy and self-determination. You'd want to know also what medications are they currently taking. And as we all talked about, it's like, what's the difference today between what was going on in the hospitalization? It seems likely that capacity may have changed. It certainly is valid to begin to take a look at that. Other questions or comments? I think you've, on to the next slide, I think you've hit some of the key points. And I would point out, I think for those of you who are clinicians, sometimes you get a referral and it becomes really important to sort of clarify, how come you want to know? What is it that you really need to know? Like I said, in this case, does the person have dementia? And what's the relevance in terms of her living, medical decisions, et cetera? And sometimes a conversation directly with the referring physician could be really helpful. And as you pointed out, really, the family may be key in terms of determining what's different and how come they want to bring about some reevaluation of the individual. And as you point out, looking at the previous reports, determine what's different, what might have been contributing factors then, and as I said, also taking a look at what medications might be impacting the individual. Other questions or comments? I want to go on to another piece, and it has to do with surrogate decision making. I think the natural default is to refer to the patient, ask them what they want. But there are times, especially if we want to involve the family in surrogate decision making, is to understand, well, what is the state statute about that? In best practice, people have an advance directive. They've designated an agent. They have a healthcare directive or a living will, so they've specified what they may or may not want. I'm not sure what the current statistics are, but several years back, maybe 20–30% of Americans had advance directives. So when there's a question about capacity, it really becomes touchy. It's like, well, who do we talk to? In the state of Nevada, the surrogate schema is that the spouse of the patient is the next person to speak to. If there's a question about what you have and the person lacks capacity. If a spouse is not available, then adult children. And again, recognizing that if there's more than one child, you really want to have a consultation to be sure everybody's on the same page, their questions are answered. Again, this is not in situations where the person's a minor, but if there is no spouse, if there are no adult children, then it's the parents of the person. If no parents, then we go to the adult siblings. And again, it's like, how many are there? Who's involved? What's their level of involvement? I want to point out that number 6 really is very specific to the PULSE statute. So any adult who has exhibited special care or concern for a patient, is familiar with the values of the patient, and willing and able to make healthcare decisions for the patient, can actually sign off on a PULSE document. I was reviewing the state statute because I was curious about other sort of places in the statute where it talks about consent. And in Nevada, this is the only place in the PULSE statute. But this is a pretty consistent guide throughout the country in terms of spouse, adult children, parents, siblings, nearest adult relative. I think when it comes down to that adult who's not related, that's when I would refer probably to legal services to get some outside help. I professionally would not be comfortable deferring to friend, neighbor, for their involvement in making a decision. And they might be helpful in tracking family down. They might be helpful in understanding what the values of an individual are, et cetera. That might be very informative, but like I said, I'm not comfortable letting them have decisional capacity. And again, I just want to point out that within the statute around the PULSE, that is permitted.
I have a question.
Sure.
So this order is for Nevada specifically?
Yes.
Okay. And every state has their own specific order usually?
This is pretty consistent across the country. Again, legal advocates, practitioners that have looked at these things, and so there's some pretty uniformity around this. I mean, this has been my experience in my career across several states.
Okay. And then kind of a question about the PULSE. Our PULSE form got revamped, I think, in the state like a year or something ago. Now much more simpler. Not much more simple, excuse me. It's kind of, what if, I guess the question that's not on there anymore is like dialysis. Since that's not specifically addressed on the PULSE. Is that something that, if you get down to number 6, that you should be utilizing that person for? Or is it only those specific things that are on the A, B, or C? And that's kind of a very esoteric tough question. I didn't even know number 6 before, so.
Yeah, but I think again, if it comes to that, I think again the practitioner would just need to document, how come the conversation, it wasn't on there, I would also assume that somebody who, it depends on the circumstance, if they're already in dialysis, the dialysis unit probably had some conversation about some limits. But if it's a hospitalized patient who requires it, I think that could be a little bit more difficult.
I mean, by the time we are at number 6, maybe like if the person really knew the person that person didn't want to be on dialysis. That's the useful information for doctors who are deciding whether or not to the dialysis, right? That can give a little insight on, how the physicians would proceed at that point. So it's good to get the input, but relying solely on that person, it's a little tricky.
Yeah. And I think in the context of the full treatment or mid-range or no treatment might provide some guidance in terms of, let's try dialysis for a while, see about the benefit, et cetera.
Thank you.
Good question.
Yeah, thank you.
Yes, go ahead.
And also for number 2, isn't it in the state of Nevada that it's actually the oldest adult child who gets to say over the other children? Because I've had a lot of, when I was doing inpatient palliative at Renown, big problems with that when we had, I remember multiple family conferences where, there's a lot of kids and they actually couldn't agree.
Mm-hmm.
And I thought, isn't the oldest child who
This is the only place I could find in Nevada statute.
really? God,
But-
I wonder
but
I might be misinformed about
my
that.
old default has always been asked the oldest child, but I think,
But I don't know if that's legal. Is that
well,
really?
according to Nevada statute, this is the only place where they specified it. Here they say if there's more than one child, a majority of the children who are is available for consultation.
Wow, that's like taking a vote.
I know, what if there's more and it's 50-50?
I've literally had that problem.
Yeah.
So, and we actually were we actually were saying as a group, in addressing this family, well, technically the oldest child. And I mean, that's
So in a
that was
hospital
just what
setting,
I learned. But
right,
that's,
yeah.
I mean,
in a hospital setting though, you have the advantage of ethics committee, and
that's what it was. It was the ethics committee.
I would take it to your ethics committee because again, you want outside consultation, and I think there's always value in doing that. Again, speaking to an expert in the field, a colleague, whatever, and getting some consultation to be careful. Having worked in a different institution around removal of life support, it had to be 100%. And again, it was the institution in terms of protecting itself legally, which is not inappropriate. You just don't want not that sort of conflict because my experience has been, again, in those situations, family members remember those days and they remember the difficult decision and there's a lot of difficulty. And over time, there might be some agreement and it takes a lot of conversation. The ethics committee can be your salvation.
Anything else in VA, Dr. McCaleb?
Just that I know when we get to number 6, we are at an ethics consult by default. And so that's who we would use. And just, to give you an example, we've had gone down to number 6. These are extenuating cases. I don't want to generalize anything here when I say this, but we've had it go down to number 6 by an ethics committee, and it was the patient's mechanic, just because the individual had their car serviced on a 3 times a year, and that mechanic and that patient were really close. They would sit, they would talk about cars for hours, touch base socially once or twice a year, and that was the only living person who could comment at all, and it turned out they'd had conversations about life and death, oddly enough, based on their shared love of automobiles. And so that person was actually able to step in and say, no, I knew, and this is what he said. So just sharing what the extent out is on, that I've personally experienced through the ethics lens and this sort of surrogate decision making.
Yeah, okay. Good example. And again, I think on the one hand, like I said, we don't want to rule out those non-family members, but there may be the point of a conversation. And there have been some cases nationally where that's actually been the case, where it's been a friend, a conversation, a coworker that had a sense of what their last wishes were. And that's one particular set of decision-making around capacity. The other that becomes more difficult has to do with the older adult who's living at home, who's not taking medications regularly, and it's not uncommon for home health agencies, other social service agencies to be dealing with that. The threshold to get guardianship in most states, all states, is really pretty high, again, because it's taking away people's individual autonomy, right, around decisions, et cetera. And where the rub at a community level occurs is that there's a community standard. The neighbors, the friends say, well, the state should come in and do something. And when we think about sort of the role of the state, whoever that is, whatever agency that is, how would you want them to intervene in your life and at what point? And those are very difficult decisions. And I think my experience of working with staff members from the Elder Protective Service is that they really are advocating for folks recognizing that there may be certain risks that people are entitled to maintain in their personal life. And I think those become really hard, I think, for family members, neighbors, but even practitioners in the clinic setting, as the families are coming in talking about their concerns, et cetera. So like I said, guardianship from the state's perspective is the last step. And there are those folks out there who are, in the community's perspective, sort of living on the edge. Usually social service agencies, home health agencies get involved and provide some level of service to some degree. And in truth, I mean, there's certainly the person lacks good judgment about their decisions, which I think ties into capacity very much. But again, it becomes really hard then to take it to the court level to have guardianship provided.
We do have the public guardian office in Washoe County and in Elko. Maybe they'd like to share something.
Yeah.
Yeah, Kathy or our folks at Washoe County, anything you want to chime in there?
Hi, everybody. This is Sue from the Public Guardian's Office. We are definitely enjoying your presentation. You're right. The bar is pretty high for guardianship. When we are presented with, especially an end-of-life decision, those are definitely where we are looking for family in any shape that may be able to help guide the doctor to that kind of a decision. Because we haven't really gotten accustomed here to the specifics we're working on it in guardianship court, and through the Supreme Court, but where we're actually looking at some sort of limitation or identifying what levels of capacity a person has. They can make decisions about A, but not about B. We are really trying to push towards that level of, so we know what our authority can be as a guardian. If a person has the testamentary capacity, if a person has contractual capacity, those kinds of things are a little bit different. So unfortunately, that takes a great deal of time to kind of unwind and figure out, and oftentimes an acute facility is not the best place to do that.
So to be sure I understand, so what you're saying is that currently there isn't a sort of a guardianship that's provisional for different degrees of decision making?
No, we do have, if you have a person who's able to make that presentation, if you come in with some neuropsychological testing where someone can say, yes, this person can make these decisions. Sometimes end-of-life decisions we like the individual to be able to participate in. Sometimes medical treatment. Sometimes it's a place where they can live. But that has to be addressed by the court, and the court is the one that gets to make that call. So the evidence is presented to the court in order for the court to make that determination. You can make distinctions between a guardian of the person can make the decisions about their placement, but they can't. They're not going to give them authority over their finances. Well, that makes it nearly impossible for a guardian to make decisions, because if you don't have control over their money, you can't pay for the place where they live. So, and people oftentimes, as they get older and progress farther in their dementia, can be less cooperative.
Yeah, that's true. And also, a question I would have for you is, my experience has been that although the guardian may have the decisional capacity, responsibility for folks, it doesn't mean that they exclude individuals in conversation or working with them. Is that correct?
Absolutely. Our goal is to include the protected person with as many decisions as possible. And also, that also includes family members, to make sure that families are allowed to visit, as long as it's okay with the protected person. You know, usually if a public guardian is appointed, there's a reason that family hasn't stepped in. And sometimes those relationships have been strained for many years.
And sometimes it's because a family member who might want to do it doesn't want to deal with their family members who are opposed or might give them some grief about decisions.
Absolutely, and guardianship is hard. There's a lot of requirements of the court now, and as things kind of blew up down in Las Vegas in 2015, that the legislature as well as the Nevada Supreme Court has reacted to that. And in an effort to provide additional oversight and protection to the protected persons, the requirements for a guardian have kind of, you know, shot up to the sky. So we got a lot more filings to the court that are required to address a person's where they are, if they want to move someplace, if they're thinking, anyway. So there's lots of additional requirements, and sometimes it's a little overwhelming for families who might want to do that.
Yes.
And how long does the process typically take? So just curious.
It really depends on where the petition is coming from. So oftentimes, right now, at this moment, the public guardian does not petition for guardianship. So we receive other people in the community, any other entity, and including families, can petition the public guardian to serve. So right now, for example, Renown, if a person is at Renown and the physicians at Renown have determined that this individual has lack capacity, they have tried to engage family. Either there is no family doesn't want to participate, then they have to gather all of the medical evidence that's required, send that medical evidence to the attorney who then creates the petition, sends a copy of the petition to this office, we review it, it's then filed with the court. At that point is almost when you start the counting, because there's legal notice requirements. For a permanent non-emergency guardianship, you're waiting a minimum of 20 days for legal notice to happen to the family members. But right now, I have seen, so we're at the middle of October. Right now, I've seen a couple of hearings that have been set at the end of November or the first part of December. So that's a really long time for somebody to stay in the hospital. We are transitioning between two different guardianship court judges, so that very well may, that time, hopefully that timeline will get shorter, but I'm not sure. So I can see from the point a person is admitted to the hospital to a point when they actually are in court receiving a guardian, I'll bet is anywhere, I would say on the quick side, 4 months.
Wow, thank you.
Yeah, we had a comment here from Samantha Gar. She said, we find the waiting time to get a public or private guardian can be close to a year for long-term care residents and skilled nursing facilities in Las Vegas.
That's unfortunate.
Sue, I'm wondering if there's any provision for the hospitals, because there's a point at which hospitalization just isn't the best place to be for a lot of reasons. That if the hospital were beginning to petition for guardianship, but we're actually to place somebody in a skilled nursing facility, how the court or the legal system might look at that. Would that it went through their ethics committee, et cetera, in terms of this is the best choice given what the person needs?
That gets a little bit complicated for multiple reasons. One is that right now there is a provision in the statute that prohibits that from happening. And I think that is a reaction to things that happened down in Las Vegas in 2015, where there was some private guardians that were appointed as the private guardian and then were moving people, and families didn't have any idea where they were. And the private guardian was deliberately making those decisions to keep those protected people isolated from their family. Not good. But the other piece of the puzzle is that if you're basing your decisions, it gets complicated because oftentimes there's no pay source. You don't know what the finances are. You don't know what the individual is going to be able to pay for. So you're asking the long-term care facility to take a financial risk on a person that they may not get reimbursed for. The other piece of that puzzle is that then you have an ethics group who are taking away the person's ability to consent to their own placement prior to being adjudicated as incompetent by a judge. And that slides into due process rights, and that is a significant issue. And at least in Northern Nevada, we don't have a lot of options. So for a while, Renown was trying to place people in a group home, agreeing to pay for the group home. And then the question is, if the individual can consent to where they're going to live, you can have a representative payee step in and manage their money. Why do they need a guardian?
Yes. Okay.
So it's kind of a circular conversation, but you're right. The time frame can be painfully slow.
And statute stuff. Thank you for that information. Because again, I understand the sort of the complexity around people's human rights by law and protecting them, and the difficulty in some situations is pretty complex. Thank you.
It really is. Just this last legislative session, they've approved the Protected Persons Bill of Rights. I'm sure you could Google that and find it, which is really specifically outlines all of the rights that the protected person should continue to have, and so specifically things that they aren't doing it right now, and it very well may change that way after this next legislative session, I'm not sure. But whether or not in the order granting the authority to the guardian, that each of those items are addressed specifically. Does this person have the right to drive? Does this person have the right to enter into a contracted marriage? Are they allowed to vote? Can this person own a gun, keep firearms, those kinds of things. So right now, the only things that are definitely looked at straight off the bat are voting and firearms. So otherwise, there isn't a lot of specific guidelines for the guardian to go by in terms of their authority, unless it's a specific issue that the judge wants addressed.
Are most individuals with a guardian now allotted the right to vote or own a gun?
Usually, no. The rules are yes to voting, generally speaking, and no to firearms. If you have a guardian, you don't get to have a gun.
Makes sense. Thank you.
If there are issues also, if you have a family who has if they're a hunting family or there's firearms in the family and dad is the one who's living alone in the house, he gets a guardian. What do you do with the guns? Generally speaking, they are taken by the sheriff's office, but if the guardian is appointed and it's not a family member, the issue of personal property comes into play. Who should get the guns? If you give it to the family, you have to have court permission in order to do that. So guardianship is really complicated.
Yeah.
It can get pretty gnarly.
All right. Thank you. It's helpful to get it, really helpful to get it from your perspective. Because again, my experience is I think that we need to get those folks in the legal systems, elder protective service, public guardianship, and the clinicians, because there are some thorny, difficult questions that come up. And typically, my experience is that families are just saying, well, let's just get guardianship. It's like, and as you all know here, that's not an easy process, and it may not even be the most appropriate option here.
And sometimes family, generally speaking, when this sort of stuff comes up, people are in crisis. They aren't thinking very clearly, and the family members are overwhelmed, where if they had someone to kind of walk them through all of the steps, it very well might go differently for them.
Mm-hmm. Absolutely, yeah.
But I agree with you. Having all of us together to have a conversation, clinicians, Elder Protective, Sanford Center, all of that would be tremendous, because I think that we each hold a piece of the puzzle.
Correct.
And together we could probably do a better job making it run more smoothly here.
Thank you. I want to go to this references. The things I spoke about today, I did go to the revised statutes in Nevada, but the book by Grass and Applebaum and Qualls and Spire were really, really helpful books. I encourage you, if you have more questions about competency, capacity, etc., to take a look at them. Several of these, both these books have examples of instruments you can use for that. I just want to point out that these instruments are not easy sort of 2-minute things. They're very lengthy, but I do think they're valuable to look at sometimes, because they might provide you some guidance around questions that you would or would not ask when you're talking to somebody to try to determine, what's the degree of capacity that they do or do not have. Again, just refer you to both of these books. They are available at the School of Medicine 7th Library. I don't know that they're available otherwise, but they are available. And depending on your particular organization, you might be able to get them on a loaner. I just want to sort of sum up just to say that this whole conversation about capacity, again, is complex. It depends on the context. What are the decisions that need to be made for an individual? Who can be involved around those questions? And for the most part, some of the questions are not necessarily emergency things. They take time. As Sue talked about, depending on the circumstances, it can take a long time. But engaging people, the family members, those people close to them, I think can be really helpful. And also rely on your team members to talk things through. And there might be social workers or nurse practitioners who can spend additional time with the patient family talking through the various things. If you have a conference necessary to talk about a treatment decision, provide the information, then others can stay by and go into greater detail, answer questions, help them sort out in terms of what are their beliefs, their values, what do they understand or not understand. And I think in many ways then we can protect people's autonomy, and you can also protect them from possibly poor decisions, not always. Anything else as we wrap up?
Well, thank you. That was awesome. I learned so much. I really appreciate it. Thank you to the audience, for everybody for contributing. I do have some announcements, but want to give the option for any last-minute questions, so feel free to chat in. I think this finishes up our 4-part series on our long-term care dementia series. I hope you all found it helpful. Again, any feedback we appreciate. Send it through the chat box. Send it however you know how, through email. We're happy to hear it. We will be taking a break next month because the third Wednesday is right next to Thanksgiving, and we want to just make sure everybody has a good quality of life as well as learning. So we will be skipping November, but we will have another one probably the third Wednesday in December again. So we invite you to that. Our topic will likely be falls, but we still have a couple of things that we're working through just to make sure that happens exactly that's most beneficial for you guys. Essentially, is what we're looking for. And then December, we'll kind of give you the update for the rest. For the next 6 months, we're going to be getting together as a team and talking about some information we've gotten from feedback from lots of people around the community to make sure we can come up with a good curriculum and good didactics, good cases, which is the most important part to share with you and that you can share with us. Any questions about any of that? Anything I missed? Anybody here?
I would just encourage everyone to submit suggestions for topics that they'd like to see in the future, because we like to hear that and address what your needs are.
Yeah, this is Troy. I think most of you have my contact information. So yeah, if there are things that you want to see presented in the future, please send those my way and we can fit those in.
Yeah, I think I hope you all enjoy it. I think we all here enjoy this a lot too, and we want to continue it. And so whatever we can do to keep that going, let us know. We have the time, so.
Thank you.
Thank you.
All right. Thank you, everyone.